Hello, and welcome back to this podcast series where we are exploring some of the key issues shaping the world of employment law and HR best practice. My name's Jess. I'm an employment lawyer and PSL at VWV.
And I'm Sarah, a senior HR consultant at Narrowkey HR. Today is the second part of our series looking at something that will be front of mind for many employers in 2025, and that's how to prepare for the Employment Rights Bill. This week we're going to be looking at the practice of fire and rehire and considering whether that practice is coming to an end as we know it. And we're also going to be looking at what organisations can be doing in practice now to put themselves in the best and most resilient position. So moving on to another headline change in the bill, this effective ban on dismissal and re-engagement, which is very often described in the media and in sort of common language as fire and rehire. And it feels like something that's been around and talked about certainly over the last few years since the P&O situation that happened and caused sort of outcry where lots of employees were dismissed without very much notice.
Yeah, absolutely. And that is really what's prompted this huge kind of policy from the Labour government to effectively ban fire and rehire. So I think there's a perception within the government that it's only really unscrupulous employers that use fire and rehire tactics and essentially threaten staff with dismissal in order to force changes through. I think most employers know that is not really the case and that there are lots of different reasons why an employer might be in a position where it needs to consider dismissal and re-engagement of one or more staff. But when these changes come into force under the bill, that is going to be so much harder to do. So it's going to be nearly impossible to terminate and re-engage workers on new terms and also to terminate workers and replace them with other workers who are doing substantially the same job. And if you do that, you will be automatically unfairly dismissing the employees concerned. And the only exception to it is going to be essentially where the employer is in such dire financial circumstances that they didn't have any choice and couldn't reasonably have done anything else but to terminate and re-engage or terminate and replace the staff. And that is likely to require objective justification. And therefore, there's going to be a really high evidential hurdle that's going to need to be met in order to demonstrate the financial circumstances that are required in order to successfully rely on that defence. And it's going to be so hard that lots of commentators think that in practice fire and hire will effectively be stopped.
Yeah, it's interesting. And like you say, Jess, we often work with clients who do use fire and rehire, but they do so it's very much a last resort, and it doesn't stop them from using consultation and to try and agree changes with staff. So it is very much a kind of last resort when all else fails. So if that's taken away by the bill or by the legislation when it eventually comes in, what are employers going to be able to do instead?
Yeah, well, like you say, there's nothing to stop changes being agreed by staff, but the question is, what concessions will an employer need to make in order to reach that agreement? In terms of practically speaking, what employers can do now when we're in this period before the bill is passed and before these changes take effect, for any employers who know that there is a big change looming for them in the near future, one sensible thing might be to start tackling that now while the current law remains in place. Otherwise, once the law does change and fire and rehire is effectively removed as an option, employers are going to need to think really carefully. So one thing you might want to think about is whether a particular scenario in reality might be a redundancy and can be approached on those terms, and employers would need to take advice on that. And if that's not an option, if you're not facing a redundancy situation, then we're going to start thinking about, approaching incentives to agreeing changes with staff. So thinking creatively about that. So things like aligning key changes to pay reviews and promotions and so forth.
Yeah, that sounds really interesting. And I suppose it's also worth remembering that we have a statutory code of practice on dismissal and re-engagement, and that remains in force for now, although I understand the government said it will be updating that to align with the new law once that's in force.
Yeah, that's correct. Yeah. So fire and rehire aside, then, what else can a resilient employer do now before the law changes? Well, first, I think, review contracts, policies, templates, and make sure they're up to date, particularly in areas that we've mentioned, like probation, hours of work, and so on, and identify the key areas where you think changes might be required.
Yeah, and I think supporting your line managers, those that are sort of on the ground day to day, because they're likely to need help being able to sort of confidently have early conversations about performance and expectations, particularly if the 2-year window for informal exits disappears.
Yeah, and I think in terms of agreeing changes, it's worth taking an opportunity to reflect on your organisation's consultation strategy. So, are your managers confident discussing changes? Have they got plans for gathering and responding to feedback? And do your staff feel listened to as a body?
Yeah, and that's an area that I often see there's room for improvement for in lots of organisations, because I suppose it's not just about the kind of legal safeguards. These are all tools that will help an organisation to manage change well. So it extends beyond making sure that you're complying with your legal obligations, because our experience is that when people feel heard and listened to, they're more likely to engage positively, even if the message itself is a difficult one.
Yeah, absolutely. And I think probably the final and the key takeaway from all of this is don't wait. So yes, the bill's not law yet, but the direction of travel is clear. It's making its way through the House of Lords and it continues to develop at pace. So employers who prepare now are going to be in a much stronger position when all these changes arrive.
Yeah, I couldn't agree more. I mean, this employment rights bill marks a massive shift in how employers need to approach their workforce planning. And it's not just about having to do more paperwork or go through more processes. It's about planning for fairer, clearer, and more stable working relationships.
Absolutely. And by taking action now, your business is not only going to stay compliant, but will also build the kind of resilience that supports long-term success.
Thanks for joining us. In the next episode, we'll turn to the role of line managers and how they can make or break your organisation's ability to manage change.
Bye, everyone.
Bye.